What is an evidentiary harpoon and how do Oklahoma criminal courts cure it? I'm Tulsa Attorney James Wirth. That's the question that we have, and it's coming up because of a case decided by the Oklahoma Court of Criminal Appeals. It is an unpublished case, Gaddis v. State of Oklahoma, F-2022-78. And in that case, there was a defendant who was charged with essentially a crime involving a gun, murder in the first degree. And during the pre-trial rulings on motions in limine, it was decided that certain evidence related to guns in the week prior could not be brought before the court. And what happened is during the questioning of an officer, the state asks, they were asking about the information they found on his cell phone, and they said, in the week prior, did you find any communications talking about having a gun? And that was a question that was specifically ruled that could not be brought in, but it was asked quickly, and before the defendant's attorney could even jump up to object, the officer very quickly said yes. So we call that an evidentiary harpoon. They actually defined it in this case, although I would define it a little bit more broadly because it can apply to a lot of circumstances where there's an intentional surprise, most of the time in bad faith. That would be an evidentiary harpoon, but this is what the Oklahoma Court of Criminal Appeals defined it as. An evidentiary harpoon occurs when an experienced police officer makes a voluntary, willful jab statement interjecting other crimes, which is both calculated to prejudice and is actually prejudicial to the rights of the defendant. So a little bit more broadly here, because we're not talking about bringing in prior crimes, which may be a more common way of doing it, but here, evidence that the court had specifically determined was inadmissible, and the state very quickly asked the question to get it in before the state could object, and it's already out there before the jury. That bell cannot be rung is what the defense would say. But the title of this is How Does an Oklahoma Court Cure It? And that's what the Oklahoma Court of Criminal Appeals had to decide here. And this is what they held. They said, we have held that an admonishment will cure the error of improperly presented testimony. So essentially, when a prosecutor, contrary to a ruling the judge already made saying something's inadmissible, asks that improper question, and the professional police officer who testifies frequently, there's normally professional witnesses, quickly answers with a yes before the defense has an opportunity to object in order to get that before a jury. When that happens, what the Oklahoma Court of Criminal Appeals says is we cure that by the judge saying to the jury, hey jury, what you just heard there, ignore that. That's your admonishment. And they say that that cures it. Yet, as criminal defense attorneys, we see that these bad actions by officers and prosecutors keep happening. And the reason, obviously, would say the reason why is because there's no repercussions to it. The defense in this case requested a mistrial because the state intentionally appears, violated the motions in limine in order to get this evidentiary harpoon in. So they're saying that should be a mistrial. But what the Oklahoma Court of Criminal Appeals says is, admonishment will take care of it. And that kind of explains why I think we still see these things of prosecutorial misconduct occur again and again, because there's no repercussions and it helps them secure the convictions that they want. But that's what we have in this case, and that is the answer to how to Oklahoma courts cure a evidentiary harpoon. They do it through an admonishment. If you've got questions related to a criminal defense matter in the state of Oklahoma, you're going to want to talk to an attorney privately and confidentially to get actionable legal advice. To get an appointment scheduled with an attorney at my office, you can go online to makelawEasy.com.